Any mention?
Yes.
Please, Your Lordship. Your Lordship, I beg to make a mention for item number 22, Your Lordship. Your Lordship, I pray that this matter may come up after 3 weeks, Your Lordship. 22.
22. Who is for the state?
Yes, state. We have no objection. Sir Gurung is
22. At the request of the petitioner. List after 2 weeks.
3 weeks, Your Lordship.
3 weeks. Oh. 3 weeks.
Your Lordship, similar prayer, joint request for item number 27, Your Lordship.
27.
Joint request, Your Lordship.
After?
After 2 weeks. 2 weeks, Your Lordship. Joint request, 2 weeks.
27. The joint request.
Oblige, Your Lordship.
Please, Your Lordship. Your Lordship, beg to mention item number 29, Your Lordship. On behalf of the respondent, number 528, Your Lordship. I pray if Your Lordship can have this matter after 2 weeks, Your Lordship.
No objection, Your Lordship.
Here for the
Petitioner, Your Lordship.
For respondent 2 and 3, Your Lordship.
I am for 1 and 4.
yes. At the request made on behalf of respondent number so and so. List this matter. When do you want it?
2 weeks, Your Lordship.
After 2 weeks. Yes.
High level, Your Lordship.
May I please, Your Lordship? Lordship, beg to mention item number 21, Lordship. I pray this matter may come up after 3 weeks, Your Lordship. I am for respondent 3 to 5, Your Lordship.
No objection, Your Lordship.
No objection.
No objection, Your Lordship.
Item 21.
Yes, Your Lordship.
This also at the request of so and so. List after 2 weeks. Yes.
Much obliged, Your Lordship.
Please, Your Lordship, I beg to mention item 25, Your Lordship. This matter is that POXO matter where they pending division bench.
No objection, Your Lordship.
Oblige.
Just make it 3 weeks. Yes. 25. Okay. Yes.
Oblige.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 12, Lordship. Lordship, I'm praying this matter may be listed after 2 weeks.
Which is the other side?
May it please Your Lordship. Lordship, item 12 is linked to item number 8 and 9, Your Lordship. So if one is to be adjourned, then the rest also will have to be adjourned, Your Lordship.
8 and 9, who is appearing?
I am for the petitioner.
No problem. I just say all these things. This thing at the request made on behalf of the petitioner. Not objected to by learned counsel by paying the respondents. List this matter after
3 weeks, Lordship.
after 3 weeks.
Apply,
Should be
Lordship.
8 and 12. Yes.
Lordship, similar prayer for item number 14. Lordship, this matter is still pending before the division bench, Your Lordship.
No objection, Lordship. Actually, Lordship, the matter is pending. It's listed today, Lordship, for hearing.
It's coming up today.
Yes,
We-
Lordship.
When shall we have it then?
Lordship, the matter is a fixed matter for today and tomorrow, Lordship. Lordship may have it after 2 weeks.
Okay, it is submitted by the parties that the connected matter pending before the division bench is yet to be disposed of. Stop. In view of the submission, this is matter after 3 weeks. We'll make it after 3 weeks.
Lordship.
Your Lordship, I'm appearing for respondent number 5.
Yes, just record her.
Oblige.
Oblige, Lordship.
Your Lordship, I beg to mention item number 31, Your Lordship. I'm praying for 3 weeks' time, Your Lordship.
So, Lordship, yes.
That is the request made on behalf of the appellant. This matter after? When?
2 weeks, Your Lordship.
After 2 weeks. Yes.
Apply.
Oblige, Your Lordship. May it please Your Lordship. Your Lordship, I beg to mention item number 28. Your Lordship is the joint request. May the matter come up after 2 weeks, Your Lordship.
You're making a mention on behalf of?
Petitioner, Your Lordship.
Yes.
From the respondent, Your Lordship, the standing counsel is on our station.
So you have no objection to the prayer?
No, Your Lordship.
Okay, 28 also. Prayer made on behalf of the petitioner. List after? When?
After 2 weeks, Your
After
Lordship.
2 weeks. Yes.
Your Lordship, I beg to mention item number 24, my lord. It may come up after 4 weeks, my lord. The conducting counsel, he has undergone surgery. It may come up after 4 weeks, my lord.
Yes. Is undergone surgery.
Yes, my lord.
What is this? Yes, item 25. It is submitted by MS so and so, Garnet Council. That Mr. M. Sharma, London Legal Aid Council for the appellant. So item 25 you said, is it?
24.
24, my lord.
Sorry, this will be item 20, huh? Okay, just say, just a request has been made on behalf of Mr. M. Sharma, London Legal Aid Council for the appellant. Urgent the matter on the ground, the London Legal Aid Council has undergone a surgery and requires time to recover. What is it? Request has been made to adjourn the matter, isn't it? Okay. Yes, sir. Okay, yes, sir. You make it a prayer has been made. Okay, let's make it the same. You just say prayer aloud. The list after 3 weeks. You will keep it.
Okay, my lord.
List after 3 weeks. Yes.
May I please, Lordship, I beg to mention item number 10 and 11. These two matters are connected and relating to same issue. Lordship, SLP is pending before the Honorable Supreme Court, and the matter was listed on 3/4/2025. An order was passed. Order was there that the matter will be listed after 8 weeks. So
Item
the
10 and 11.
SLP matter will be relisted after 8 weeks.
After
So,
10 and 11.
yes.
The matter pending before the apex.
Apex Court.
What
That
will
has a direct bearing in this case.
Hmm?
That has a direct bearing. So I pray that the
So
matter may
the-
come up after
whatever
8
the
weeks.
apex
Lordship.
court decides.
Then this matter is also decided.
This is
Because already a division bench has decided in favor of the petitioners. So that the respondent at SL. So the matter may come up after 8 weeks, Lordship.
yes, sir. It is submitted by the parties. That the connected matter pending before the apex court is yet to be disposed of. Stop. Just say in view of the paragraph, in view of the submissions. So, come on, this matter after 8 weeks. Yes. So, 10 and 11.
May I please, Your Lordship, I beg to mention item 20. Your Lordship, in this case, I represent for respondent number 3, but at this juncture I was suspended. So till now I have not, we have not received any instruction for the from the acting chief.
Appear for respondents 1 5. Yes.
No objection, Your Lordship.
So when do you want it?
4 weeks.
Yes, sir. The request made on behalf of respondent number so and so, so and so. Come on, not objected to by the London Council appearing with the petitioner. This is matter after 3 weeks. After 3 years. Yes.
Deeply right. I please, Your Lordship. Lordship, I beg to mention item 32 and 33.
Yes.
Lordship, I pray for 2 weeks time, Your Lordship.
Why 4 weeks? You are appearing for?
Respondent 1 and 2, Your Lordship. Conducting counsel is in this scope.
Respondent number 1, 2.
2, 3, and 4, Your Lordship.
District Council.
For the state, my lord.
This council.
Respondent number 1 is for the state. Formal party.
State is a formal party.
Lordship.
2 weeks. 2 weeks. I pray for 2 weeks time, Your Lordship.
2 weeks time. No objection.
Yes, sir. The request made on behalf of the respondent number so and so. This is matter after 3 weeks. 3 weeks, not 4 weeks. Yes.
May please your lordship. I beg to mention item number 26 on behalf of the conducting counsel, Mr. J. Shalla, praying for 2 weeks' time, your lordship.
With the other side. Yes.
Your Lordship, it seems that they have been praying time from they have been continuously praying for time, Your Lordship.
What is the matter about?
This is a civil revision petition based on the appeal filed by the respondent for opening of further evidence based on a new document that they had received.
Please say it again. This court could not follow.
Your Lordship, this is a civil revision petition wherein the respondent had succeeded in an appeal where they had prayed for opening of further evidence, and we're against that order, the appeal order, Your Lordship.
In a trial.
Your Lordship.
It was in a suit.
Your
The
Lordship.
evidence was closed.
Your Lordship.
Now they have made a prayer for reopening.
Your Lordship, based
And
on
it
a
was
new document that
It was allowed.
Your Lordship. it
So
was
why
allowed.
you are before this court?
Your Lordship, I'm just appearing on behalf of the conducting counsel, Mr. J. Shalla, in this matter. I'm acting on instructions. I'm praying for
Any
2 weeks'
interim order
time.
passed by this court?
Uh,
Any interim order?
No, Your Lordship.
That's okay then. Just say. The request made on behalf of Mr. J. Shilla, learned counsel appearing for the petitioner. This is matter after.
2 weeks, Your Lordship. I'm praying.
I don't think your matter has been. The proceeding has been stayed. I don't think it's. If there is no interim order, there will not be any bar for you to proceed with.
Your Lordship, actually, the instant civil revision is against the judgment passed by the judge of GHADC. It is the judgment passed in mis case of an appeal, Your Lordship, not of a trial.
Judgment of the passed by a judge.
Yes, yes.
Not
No.
not by this thing subordinate district council
No,
court.
no.
It's a order passed by district council court.
Yes, Your Lordship, the judge.
This is an appeal, Your Lordship, that the respondents had filed.
No, things are confused. Anyway, just see. Council is
Lordship.
not there. We'll just see on the next date. Yes.
Highly obliged, Your Lordship.
Item number 1.
Yes.
Your Lordship, I pray for some accommodation in this matter, Your Lordship. The conducting counsel, Your Lordship, she's indisposed, Your Lordship. She's unable to.
What is the matter about?
Quashing of the criminal proceeding pending in the subordinate district council court and the FIR dated 6/12/2024, Your Lordship.
You are seeking quashing of a CR case.
Yes, Your Lordship.
So why state is a party here then?
My lord, they have filed an FIR, and my lord, the FIR is pending for investigation, my lord. So, my lord, it is premature, my lord. When the FIR has been filed and the investigation is still in progress. Lord,
But then what is the prayer?
here, my lord, they have filed a CR case
Okay, so they are seeking.
pertaining to the
Okay, they are
as well
they are
as
seeking quashing of both FIR
both,
also
both, my lord.
in one petition.
Yes, my lord.
And what is the ground?
Your Lordship, that the court, the subordinate district council court lacks jurisdiction to try this matter, Your Lordship, to issue summons in this matter, because this matter, Your Lordship, the place of occurrence happened in European ward, Your Lordship.
Okay.
And there was no compliance with section 210. Pending of investigation report to be called by the subordinate.
That is okay. Once you say that it's in European ward,
Yes, Your Lordship. Paimon Rich European ward, Your Lordship.
we'll issue notice.
My lord.
Will issue notice?
Your Lordship, then pray for interim stay, Your Lordship, of the proceedings, Your Lordship.
What
regarding the
interim stay will be
proceedings?
considered after the other side appears.
My lord.
We'll consider it on the next day. Third, Learned counsel for the petitioner. Issue notice. We'll give a shorter time. So since you have this thing,
Yes, Your Lordship.
returnable in 2 weeks.
So,
Okay.
yes, Your Lordship.
So there are pro forma respondents also.
Yes, Your Lordship.
You have to take steps for everyone.
Yes, Your Lordship.
Mr. Singhal. You will appear for only one respondent, number one.
My lord. Only one response.
Your GA or PP or
My lord, additional PP. Huh? No, assistant public prosecutor.
are you sure that has been
My
confirmed
lord.
with this? Because there are some lawyers, who say, some government advocates, they say they have not been confirmed with this. So
No,
we don't-
notification has been issued, my lord, for as per as our names are
Mr.
concerned.
Mr. Singhal, unless assistant PP. APS for respondent number one. Stop. The petitioner shall take steps for service of notice upon the remaining respondents within 2 days. You take steps within 2
In the
days.
meantime, Your Lordship, I pray, Your Lordship, for stay, Your Lordship, till returnable
That
date, Your
will be
Lordship.
We
considered.
consider it on the next day. Just say, give a stop.
Because maintainability of this
Next time you
petition
say
also,
the
my
prayer
lord,
for interim relief would be considered on the returnable date.
as well as the issue of maintainability, my lord. Because
That will always be remain
my-
open. Hmm? Why you
my
say
lord,
it
they
is not
have
maintainable?
clubbed together both CR case as well as the FIR, my lord.
So then you have to
Those
show
are
us
two
some law.
different
that-
proceeding,
You
my
have to
lord.
show us some law.
My lord.
Please come with that. That will the question will remain open
lord.
definitely. Then there is a miscase also.
Yes, Your Lordship.
Miscase you just say list with. In the miscase only just you say list with criminal petition number 22 of 2025. List along with criminal. Okay.
Obliged.
Obliged.
Item number 2.
Please, Lordship. Lordship, this matter, Lordship, the post-mortem, Lordship, it's done. I'll produce the report on the next day, Lordship.
What for you want to produce this report here?
Because
Let him file it.
recently the dead body was
See,
exhumed.
the thing is that the contention of the petitioner is that there is no investigation. Now, if investigation is progressing,
It's progressing, Lordship, investigation.
My lord, we have filed this petition for changing of the investigating agency, my lord. Now, what has happened? We are here before your lordship on this is the second time we are here before your lordship by filing this petition. Earlier, we had filed a petition under 482, my lord. Now, at that time, an affidavit was filed saying that the investigation is almost over and we'll file the charge sheet. My lord, this is a case where, my lord, initially the case was an attempt was made to brush everything under the carpet by registering it as a UD case. Subsequently, my lord, we filed an FIR and a case under section 302 was registered against a named accused. My lord, despite being the name accused, my lord, the accused person was never arrested. Rather, he was given an opportunity to obtain anticipatory bail, my lord. He obtained anticipatory bail, my lord. He obtained anticipatory bail for the reason that the police never objected, never appeared, never produced the CD before the court, and the court below was compelled to give him anticipatory bail. Now, thereafter, we filed 482 petition, my lord, here. Now, after we filed the 482 petition, my lord, some semblance of investigation was done. Then thereafter, my lord, they said that they will be filing the charge sheet. That charge sheet was never filed, my lord.
now whether can they say that they will be filing the charge sheet without proving the case?
No, my lord. Now, what has happened, my lord? Now, earlier, my lord, when they filed their affidavit, they submitted a post-mortem report. My lord, when the post-mortem report was such, my lord, it appeared from the report itself that the post-mortem was done even without dissecting the body, my lord. The cause of death was recorded as asphyxia due to drowning. Now, my lord, the facts of the case is such that this person, my lord, it is alleged that he fell from 80 feet height. That's a 80 feet uneven height, which is a waterfall, man. Now, in the inquest report as well as in the post-mortem report, my lord, it is shown that there are no marks in the body except one mark in the forehead and a deep cut behind.
Anyway, now here is a submission of the additional PP that a postmortem has been conducted.
Now, my lord, now what they have done after we filed this petition, they again woke up from their deep slumber. They filed a petition before the court telling the court that since in this petition we had made several allegations, so they filed a petition in the CJM's court saying that we need to exhume the body. Now, my lord, I have the instructions, my lord, when the body was exhumed from the grave, my lord, the coffin fell 3-4 times, my lord, and the exhuming was done after 2 years, my lord. So what is left there is only bones.
So, what can be done at this stage by the
My
court?
lord, let them file an affidavit that they are doing the investigation, my lord. Then
That
thereafter.
that has been submitted. So this has been recorded also the last thing. That is what has been recorded already.
Let them file
is
the
submitted.
affidavit, my lord.
We'll bring it on record and then if necessary, we'll file the affidavit. The investigation started, Lordship, and
Okay. We'll just say.
Lordship.
Just say. Mr. H. Kanwi Landed, additional PP, has made a submission that the body of the deceased has been exhumed and a fresh postmortem was conducted. Stop. Let an affidavit be filed. Who is the party here?
a state respondent.
State respondent represented by whom?
My lord,
Yes.
state respondent represented by the superintendent of police and the officer in charge. Commissioner and Secretary Home, Superintendent of Police, Officer in Charge, William Nagar, PS, and
Four state respondents.
the doctor also who had conducted the initial postmortem.
He's impleaded by name, but he's a government medical officer, so I can appear.
We have specific allegations in the writ petition, my lord, that the postmortem was not done as per procedure. The postmortem was completed in less than 45 minutes, my lord. The IO never visited the place of occurrence.
That is
Never
not true.
postmortem which is being conducted now.
No, which was conducted earlier.
That is okay. That is okay. That is the reason why you are before this
Yes, my
court.
lord.
Now,
Let them
what
file
he
the
is saying, that is the outcome of fresh investigation. So that is what we need to see. You just can't cut it. Just cast this thing. You just on the last occasion, it was submitted by the learned additional PP that the body of the deceased was exhumed for conducting this. You see, you are conducting a full investigation, isn't it?
Yes,
It is
Lordship,
not
yes.
that any order has been passed to partly do something.
No,
No,
no.
my lord.
He's conducting a full investigation.
This is the resumption of fresh investigation. Is it?
No, it's not
my
a
lord.
fresh. It's not a fresh investigation.
My lord, it is not a fresh investigation. Now, my lord, what happened? After we filed the criminal petition before this court, they filed their respective affidavits saying that investigation is almost in the verge of completion.
They filed
and
an affidavit here.
in the earlier petition, my lord. It is on record, my lord. I've included here, my lord, in the writ petition. My lord will kindly come to the affidavit filed by them.
Asha, just me. I will just say what we said. Further investigation stuff. The learned additional PP has made a submission today that a fresh postmortem was conducted.
The date also is there, Lordship, on the 2nd of this month.
Was conducted.
No, exhume. Date of exhumation.
It's okay. Was conducted on the dead body. So was conducted on the body of the deceased. And the report thereof is still awaited.
Report. It's done, and the report.
Okay.
I'll produce
And
the
a
report. Lordship.
and not the report, and the report has been prepared.
He'll send it to me.
Just a minute. It's submitted by the learned PP that the shall we say progress of the investigation?
Yes.
Yes, Lordship.
Submission that the progress of the investigation of the matter may be allowed to be brought into record by filing an affidavit.
Yes.
Prayer allowed. Prayer allowed. Stop. List this matter. Yes, prayed for. List this matter after 3 weeks.
Yes, 3 weeks.
After 3 weeks.
3 weeks.
You bring all those documents also along with.
And Lordship, for transferring also the investigation, the law is that they have to show that the current investigation is biased
That is
or
okay.
inadequate.
We'll
or
go to that
modified.
thing. We'll see later.
Yes, Lordship. Oblige. Oblige.
File the affidavit.
Item number 4.
So what happened to the earlier investigation?
My lord, no investigation was conducted.
That is okay. That is for you. It's all right. But then the
They
question
filed-
is to them. What happened to this thing?
After
Because
they
you
have filed
closed the
a-
case, and then now, do we consider this one as a fresh investigation, or it's a continuation of the earlier investigation,
It's-
or
It's a continuation.
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 It's not a fresh.
so you said that UD case was registered?
That is UD case. They have filed a FR.
My lord,
They filed
firstly,
FR.
they registered as a UD case. They
There was
filed
no
an
FIR.
Then after we filed the FIR, my lord, they registered
After
a
the
case under 302
There was no
with the
FIR
name accused,
initially.
and that
So
accused
now
person is never arrested, my
there
lord.
is an investigation under 302.
Yes.
Under 302.
Okay, okay.
Initially, there was no FIR, so it was registered as UD case. After the FIR, we registered a
Here's my
case and
understanding, my lord, how a case
took
under
up the
302 is
investigation.
registered, and this person who's named in the FIR is not arrested. Till date,
here
no arrest.
he obtained bail, Lordship. Immediately, soon after that,
Because
he got
this
bail.
court is under confusion, like as to what is happening, whether there is a final report in the earlier case and there's a fresh
UD case
institution or
only.
fresh
In the UD
institution
case,
or
there
what?
was a report.
Anyway, it's
Initially, it was registered as a UD
UD
case.
case.
Obliged.
Obliged, Lordship.
Item number 4.
Yes.
Lord, I'm appearing for the respondent number 6, my lord.
There is no appearance for respondent number?
I'm for respondent number 6, my lord. The rest of the respondent steps as taken by the petitioner, they were supposed to file the affidavit to that effect. Nothing much left in this case also, my lord. They have come
No,
against
they have already filed an affidavit,
Well,
Mr. Karim. As for the last order, for respondent 1 to 5, they have filed. But then there was no appearance.
Well,
When there is no appearance of the petitioner also,
well,
then
nothing
non-appearance.
remains actually in this case, my lord. This is with regard to the non-consideration of the miscase for injunction before the trial court. And during the vacation, they had come before this honorable court. And thereafter, the matter was fixed, I think, in the month of February. Then subsequently, the matter was fixed for hearing on the miscase on 15th of this month. The hearing of the injunction, my lord.
So that has been taken up then.
It doesn't be taken up.
So matter has become infracted.
It becomes infracted.
That is why there is no appearance.
Well,
Anyway, you cannot pass any order in
Well,
their absence. We'll just
well,
see in the occasion.
well.
None appears for the petitioner. Stop, Mr. L. Kiriam Lanet. Counsel is present on behalf of the respondent. Number 6. Respondent number 6.
Well.
Just a list after 2 weeks.
2 weeks. Obliged.
Yes.
Item number 5.
Yes, Lordship.
Yes.
Lordship, the pleading counsel, Lordship, Mr. S.N. is under some difficulty, Lordship. He's on legs before point number 2, Lordship. Lordship, this matter can be taken up some other day, Lordship.
Yes. No objection.
No objection.
Okay. Prayer has been made on behalf of Mr. Yes, and run it. GA appearing for the petitioner to adjourn the matter. Stop. The learned counsel appearing for the respondents have no objection. Prayer allowed. List after 2 weeks.
Lordship.
Yes.
So 13 and 17 are connected.
Both same order.
Yes.
Same parties.
Same parties.
17. Yes.
Item number 15.
Yes.
Please, Your Lordship. Lordship, on the last occasion, we had submitted a written synopsis in this matter, and the petitioner counsel was supposed
There is no such order, only is adjourn of the prayer of the petitioner.
Lordship.
So he is absent today.
Lordship.
None appears for the petitioner. MS Sogra Learned advocate is present on behalf of the respondent. List after 3 weeks.
Lordship.
Yes.
Item number 16.
Lordship, 15 and 16 are connected. Lordship.
Same order.
Lordship.
Same.
Item number 18.
Yes.
Lord, prayer in this case is direction to grant the employees of the district courts the benefits which are available under the City Commission's report, my lord. If your lordship will kindly see the prayer. At page 26, your lordship will find the prayer. This is Abjit Sirgar. Sorry,
Yes.
So prayer, my lord, is that
Page 25, my lord.
25. Now, my lord, there is another writ petition filed by the officers of the registry, my lord. Name is Sri Abjit Sarkar and 113. There also they seek some similar prayer, my lord, in respect of the officers of the or the employees of the High Court, my lord. So my request was that if both the matters are tagged and heard together, because ultimately the issue
The other matter is pending before this court.
The other court, my lord. But issue is will be similar in this court, in this matter and that matter. So it should be heard by one bench. My request is this.
My lord, I beg to differ, my lord. The other matter is nothing connected to this matter. Lord, you would have already seen this matter. Today's matter relates to enforcement or implementation of the Shetty Commission reports vis-a-vis the lower judiciary staff. My lord. The fresh matter, the new matter, which is before the other bench, that is for enforcement of something completely different.
It has nothing to do with implementation of Shetty Commission.
Nothing to do with Shetty Commission. It is something to do with some. I'm not part of
Is
it.
it correct?
If your lordship, I read the prayer, both the prayers. Before the file is with me, my lord. Both the prayers. I'll read the prayer here and read the prayer in the other petition, my lord.
The other matter, you are not there,
I'm
Mr.
not.
Jindal.
I'm not.
But then why don't you have a look on that? And
If I can
before
get a
you
copy of that,
Yes,
maybe
I'll
I can.
give the copy.
just show him that. So what shall we do to
If this matter can come maybe on Monday.
Or next after a week or so. After a week. maybe.
If I can get a,
request made with
if I can request a copy.
list this matter after a week.
Simple petition. Annexure.
I'll give you.
Let's see if it is pending before.
Because
any
the,
other
if I can read the prayer, my lord.
then this
I-
court may not.
No, my lord, I had actually anticipated
Being
that.
the last court.
I completely understand that, my lord. I had anticipated this ground may be taken, so I had actually checked up that other petition. I don't have a copy, unfortunately, today. It is nothing connected.
Anyway, just see. We'll have it
Because
after.
this is service rules of my lord Meghalaya District Court's Ministerial Service Rule 2000, and where the direction is sought to amend the rules. In the other matter, the direction is, my lord, that High Court Meghalaya Recruitment and Conditions of Service Officers rules, and both are asking for implementation and amendment, my lord. So the crux, the issue is, it's a
It is
legal,
a related, like
legal
interrelated
question
or
is legal
interlinked.
question is will be say some similarity will be there, subject to what my friend
Anyway,
said.
let Mr.
Very
Jain
well.
clarify.
My friend says that the matter is to be argued. We will argue the matter.
Anyway, let him verify and then we'll
That is it.
because for the last 1 year we were waiting for Supreme Court to decide, but now we know that nothing is pending in the Supreme Court. Now this issue has come. This also, my lord, in my humble submission, I substantiate it has no connection. One has no connection with the other. I'll substantiate. But then, if there is any recommendation by commission, why
Yes.
don't you implement it? Why
No,
you
because
unnecessarily
it's as simple as that.
drag them to the
No, but
litigation?
the issue is, my lord, if your lordship will examine that the recommendation of SETI commission was pending before the Honorable Supreme Court. In 2001, first judgment came, All India Judges judgment came. In that judgment, directions were there, and the implementation was being monitored. That SETI commission was constituted by the by the central government, and there were certain provisions where the states have raised certain objections as to the provisions of SETI commission, my lord. Those were the recommendations. Then those recommendations were gone into by the Honorable Supreme Court. Honorable Supreme Court in Article 142 issued directions for implementing it. We have implemented a part of it. Certain parts are pending, and we are also raising those objections as to the financial.
Once there's a direction by the apex court, what is the friction of yourself raising this objection?
No, but they were directions. All recommendations of SETI commissions were not accepted.
Whatever has been accepted by the
we
apex
have
court,
implemented it. We have implemented it.
because his prayer is confined to that only.
No, if there is a prayer, if your lordship will see that the prayer is to amend the rules also.
To the extent it's required by the implementation of the SETI. So once
Now-
SETI commission is implemented, naturally the rules also would be
It will
affected.
be consequential upon this thing.
Yes, and
Now
it's a natural
the
consequence.
issue which will legal issue which will arise, whether the direction can be issued for amending the rules. Because those
We'll not say a direction for to amend. We'll say you'll do the needful to
because-
implement the recommendation.
the issue
And then
will-
whichever we do,
issue-
you do it, you do.
No, because without, if the rules do not give them those kind of benefits, my lord, then ultimately direction will mean that we have to amend the rules.
We do not know, but then if there is,
So therefore-
there is direction by the apex court, then that
And
definitely
if
you
there
will
is a
have-
direction, then
you will
there
have
is no issue. Then there is no issue because I am bound by those directions. I am bound by, I can't raise, but there is no direction in these cases also. That is also my case.
There
That
is
is
a-
also my
in
case.
2009, my lord,
That
there
will-
was a clear direction. 2009 there was.
We'll see. We'll see. try
And
to
similar issues have been
determine.
there in the other high courts. I checked up with the Calcutta High Court, even the High Court of Madras also. There was some certain, because this issue has been there throughout India in various high courts, my lord. So we will assist your lordship once my friend comes to the
So
conclusion.
all other high courts, these are disposed of. The matter.
No, it's pending because these issues are quite, because these are all financial implications having on the state. The capacity of the state to finance, capacity of those directions are in the nature of recommendations. Whether writ of mandamus would lie to enforce those.
Can it be a ground for not
No,
implementing the direction?
the issue is, my lord, that when it comes to the determination of pay and salaries of the employees of the state government or the employees of the district court officers or employees, the question is that who has the final say whether, if I have the financial capacity to pay the salaries to them, to the ability, whether court can, in exercise of power under 226, issue direction to the state that no, you give fix X salary or Y salary. Determination of salary is also an issue because they are asking for higher salary.
And we'll just see what is the direction.
Yes,
of
my
the
lord.
Shetty
Yes,
Commission.
my lord. If the direction
So
is
what
there,
is the-
then there is no issue. There is no issue. We'll have it after a week or so.
A week.
We'll have it after.
Well, best.
Item number 19.
Yes.
Is that check gate matter, Lordship, non-tribal?
Non-tribal check gate. Yes.
So this can come up after 2 weeks, Lordship.
Yes.
No objections, Lordship.
Yes, sir. At the request made on behalf of the. Oh, sir. Just one prayer made by the petitioner.
Is this matter after 2 weeks? 2 weeks.
2 weeks. Okay.
Item number 23.
So that way there will be no this thing, conflict of interest, isn't it?
Lordship, it's subject to your lordships.
Verify, because if
Lordship, we understand.
at all this court has played some part as a lawyer in some litigation.
Lordship had appeared in that matter basically.
So that will be then it will be in such a case. Let it go before any other bench.
Lordship will examine. Let it come after 2 weeks. We'll examine the aspect.
Once you say that we have appeared in at
Lordship,
least
it's
for
the
either
orders.
for this party or that party in connected
Lordship.
matter, so I think
Lordship,
it will be better. You try your.
The order is at page 40 of the petition.
Anyway, we'll just see it on the next stage.
After
since we
2
have
weeks,
already passed out. Okay.
Highly obliged.
Yes. Yes. This is item.
Lordship, item
Yes.
number 19.
No, that is okay. That's all right.
Highly
It's in-
23. Item number 30.
Yes.
Yes, my lord. My lord, this is a civil revision, my lord, wherein our written statement was closed, my lord, prior to the lapse of 90 days period, my lord.
Is it?
My lord, the order was passed on 21/11/2024, my lord, where it has been reflected that 90 days period has been over and our written statement has been closed, my lord. But if we calculate the date, my lord, on the day when the petitioner, she has received the notice, my lord, 90 days period would be over only on 27/11/2024.
27/11. But
Yes,
then
my lord.
your opportunity was closed on 21/11.
21/11, 84
Yes,
days, my lord.
This appears to be an inadvertent mistake, Lord, because we had inquired from the bench assistant. They told us it was received on 38/24. 90 days had expired. So we also did not check. So this may be set aside and matter may be sent back.
Okay. And sending back means like then
Giving them the opportunity to file the
File
written
our written
statement
statement, my lord.
within that specified time period. Otherwise, they'll again take.
that means another 1 week's time.
Lordship.
That is what this arithmetic. There has to be simple arithmetic, isn't it? Let's see. Atlanta Council for the parties. Paragraph by this revision petition. The petitioner has challenged the order dated the impugn order dated 21/11/2024 passed in TS within bracket you write evict EVICT. You'll get it here in the petition in the paper monkeys. C stroke number 21H of 2024. What is it passed in? By the court of the Assistant District Judge Shillong, whereby the opportunity to file the written statement by the petitioner was closed. Stop. Give a paragraph. It is submitted by the learned counsel for the petitioner that the learned assistant district judge committed a gross error of law and fact by closing the opportunity to file WS without taking into consideration the date of receipt of notice by the petitioner in the case and expiry of 90 days thereafter. Stop. According to the learned counsel, the 90 days, the stipulated period of 90 days for filing written statement would have expired on 27/11/2024.
24, my lord.
Step. It is
27.
step. Mr. Shen, learned counsel. Give a paragraph, huh? Mr. Shen, learned counsel, preparing for the respondent. In his usual fairness, did not dispute the submission made on behalf of the petitioner. And submitted that it is because of wrong calculation, the opportunity for filing WS was closed. Stop. He submits that the matter may be remanded back to the trial court by giving an opportunity to the petitioner to file his written statement in the TS within bracket evict C number 21H of 2024. Stop. Your paragraph. See, one in view of the submission made by the learned counsel for the parties, the impeachment order dated 21/11/2024 is hereby set aside, the petitioner the opportunity of filing written statement in the title suit is restored. Stop. The petitioner shall now file his written statement within
2 weeks, my lord.
That's again going beyond 90 days.
My lord, my senior is still recovering, my lord. At least that may be taken into consideration. At
Within
least a 2 weeks.
I'll leave it to you, Lordship.
period of 2 weeks from today. Paragraph with the above, this revision application stands disposed of.
I leave it.
Obliged, Lord.
She's benefited by 1 week then.
1 week.